Hello and welcome. My name is Wolfgang Alschner. I'm an associate professor at the Common Law section of the University of Ottawa in Canada. This video is part of a video series of the ITA's Academic Council presenting what are we working on. So today I'll be talking about my most recent research project, my forthcoming book on investment arbitration. More specifically, my book is about investment arbitration and state-driven reform, how new treaties have produced old outcomes. Let us take a step back for a moment. About 10 years ago, commentators, scholars, and international organizations, they started to talk about a new generation of international investment agreements that had new features such as exceptions, protected public policy space, that new preambles, that had new interpretive means for state parties to intervene in the arbitration. These analytical devices, it was thought, would provide new means for international investment arbitration tribunals to more effectively balance, on the one hand, the protection of international investment with, on the other hand, the regulatory space of host states. And this, in turn, it was assumed, would alleviate some of the concerns that have been raised about international investment arbitration, notably that it is biased in favor of the protection of investors and against the regulatory space of host states. In my book, I take first stock of those international investment agreements that have that new design and that have been interpreted in international investment arbitration. And I find that new treaties have reproduced old outcomes. The new analytical devices, the new features that have been inserted into these new international investment agreements, have failed to change the interpretation in investment arbitration on a systemic level. Ultimately, I argue that this is due to the fact that old international investment agreements with outdated design coexist with those agreements that have new features. And that is because in investment arbitration practice, most favored nation treatment, customary international law, and precedent are being used as vehicles to read these new international investment agreements in light of old international investment agreements and in light of cases rendered under these older investment agreements. Now, that insight is very important because it means that changing treaties alone does not change outcome. Moreover, it means that in order to fulfill state-driven change, it is not enough to just focus on concluding new agreements that have novel features, but we really have to start tackling the stock of outdated international investment agreements, because without tackling those, there can be no successful reform even through these new international investment agreements. And that, of course, matters for the current UNCITRAL debates on multilateral reforming international investment arbitration. So let me briefly describe the structure of the book through three visualizations. Part one of the book tracks the design of international investment agreements over 7 decades. Here I use empirical and state-of-the-art computational techniques in order to identify that one difference that describes the varying design of international investment agreements. I interpret that difference to be a difference in contractual completeness. Early investment agreements were relatively incomplete, while more recent international investment agreements have filled contractual gaps through more complete contracting, through new escape clauses, through new relational language, and finally through new terms of delegation. As part 2 of the book, I show that this evolution towards greater contractual completeness is being undermined in international investment arbitration practice, as these new agreements are read in light of older, less complete agreements, as tribunals use MFN, customary international law, and precedent to read new treaties in light of old law. As part of the third part of the book, I then propose how international investment arbitration and international investment law more generally can be reformed by reading old treaties in light of new ones, so reversing what we are currently seeing in practice. This can be done through interpretation, renegotiation, and finally through multilateral reform that identifies common baselines, common best practices that can be used in order to lift up the contractual completeness of all international investment agreements, and thereby to achieve state-driven reform, not only with respect to new agreements, but with respect to the entire universe of international investment law.